Thank you very much, and good morning or good afternoon, everybody, depending on which part of the globe you are. AI systems and product liability. Did I share my screen? Not yet, I guess. I prepared some slides, which are hopefully visible now. And it's my subject, AI systems and product liability. Just let me move on, just to make it clear, I'm professor of law. I'm not technician, I'm lawyer, and this presentation is on legal aspects of AI systems. So I'm not going into detail of technical aspects. It's about the law regulating the technology in this case. What is the role of liability within the legal framework for AI systems? Let me briefly introduce. AI systems give rise to enormous expectations. We think that the world will be brighter and richer once we are establishing a framework, a coexistence of humans and AI systems in some future. However, at the same moment, there are some risks associated with AI systems. And the most striking example, which made it clear to the world, maybe was the Uber car accident 2 years ago, when a self-driving car was running over and killing a pedestrian. I'm sure you're aware of that. Another aspect of risks associated with AI systems are machine-made decisions, which is often linked to the questions of algorithmic fairness or machine bias. In this case, very often a machine is making a decision which has an effect on humans. For this presentations, I will not deal with the second group. I will deal exclusively with the risk associated to physical harm and damage caused by AI systems, such as machines like self-driving cars and others. AI systems pose a very specific challenge to the legal systems, as AI system can show what I would like to refer to as behavior. Of course, any machine can function, but what is different between function and behavior? Just as a working definition, I would define behavior in this meaning as the ability to choosing actions depending on a perceived situation, which a traditional steam machine 200 years ago could not do, but a self-driving car would have to do at any moment while it's functioning. This is a challenge to the laws, as behavior or choosing action is an ability which was attributed to humans only, not to machines, and the legal system is not prepared to a machine showing its own behavior. It's not surprising that liability is in the core of the legal discussion for an adequate legal framework for AI, at least in Europe. From 2018, the European Commission was active in this field, starting, for instance, with the communication of 2018 AI for Europe, where a good deal of the paper was dedicated, surprisingly, to questions of law, in particular liability. The next, as a step, I want to refer to the work of an expert group on liability and new technologies, which was established by the European Commission in 2018 and delivered its final report in December 2019. I will refer to this as the expert group made the conclusion that some amendments of the current legal framework are needed, in particular the introduction of new rules on liability. The European Parliament took the opportunity in October 2020 and suggested the introduction of a civil liability regime for AI systems, in particular including a proposal for regulation on liability of operators of AI systems. And most recently, the European Commission in April 2021 published its proposal for the so-called AI Act. The AI Act is a very, as its demonstrated by its title, a suggestion which introduces fundamental principles for the use of AI systems. By substance, however, it mainly restricts to the introduction of the duty to establish a risk management systems by operators and producers of AI systems. It does not refer to any liability rules, since these rules will be dedicated to a specific insurance for liability for AI systems. We expect the first proposal by the European Commission to be published in fall this year or spring next year. I want to talk about liability in AI systems. So what are the functions and concepts of liability? This is very important to bear in mind when we talk about the detailed questions. The traditional function of civil liability is to offer compensation for damage occurred. However, a second and possibly even more important function of civil liability is that it creates incentive to the addressee of liability to adapt his behavior, for instance, driving carefully in order not to be liable. When we talk about concepts of liability regimes, we should distinguish between the traditional fault-based liability, which is known worldwide in every jurisdiction which I'm aware of, where liability depends of the existence of a breach of a duty of care. You're only liable under fault-based liability if you breach a duty of care. As a contrasting concept is well known, the concept of strict liability, which exists in a huge number of variations. Basically, the idea of strict liability is that the addressee of liability is obliged to pay damages whenever a damage occurred within a defined sphere of risk. Just to give an example, under many jurisdictions, the operator of a car will be liable to pay damages whenever an accident occurred while operating the car. This is a very easy example of strict liability. The sphere of risk is the operation of the car. And these rules are very important for AI systems as well. The last aspect of the conceptual framework of liability certainly is to whom the liability is addressed. In the current discussion, there seems to be a trend on introducing new rules on strict liability of the operator of an AI system. So the basic idea is that the person being obliged to compensate for damages should be the operator of an AI system. Regarding the producer of the AI system, many authors and legislators refer to the existing framework of product liability. And that's why product liability is so interesting for our questions, since this is, at this moment at least, dedicated as serving also to or dealing with the challenges posed by AI systems. The legal framework of product liability is different, obviously, in all jurisdictions. In particular, US law played a very important role in the development of product liability rules. However, in my presentation, as I'm European and in particular German lawyer, I would like to refer to the system of the European product liability, which is applicable all in the European Union and is similarly known by the basic concepts in many other jurisdictions worldwide. The basic rule of the product liability directive is set forth in this Article 1. The producer shall be liable for damage caused by a defect in his product. So there's liability for any damage caused by the product if and only if the product is defective. So the defect of a product is the main reason or source of liability. Please keep this in mind. I will come back to this in a minute. Now, the question is, how can we apply product liability directive to AI systems. It goes without saying, and is not disputed at all, that cyber physical systems, which is a functional unit of hardware and software like self-driving cars, robots, and so ever, are products within the meaning of the product liability directive. It is still somehow disputed, or there's still some uncertainty as to the question in how far software which you can download from the internet can be considered as a product within the product liability directive. Most authors nowadays consider software being a product, and we expect an amendment of the product liability directive, which is announced for next year, which will probably expressly include software into the regime of product liability. This is an important step, as for the past 30 or 40 years, many people were thinking product is never error-free, so software should not be subject to strict liability, but that is state of, or will be probably be state of the art within a few years from now on. When it comes to AI systems and in particular systems which use machine learning to develop their function, the question arises in how far a neural network, or let's say the functional unit of a neural network and the software to run it, can be considered as a product. But obviously, if software is a product, also the functional unit of software and the data model has to be considered as a product. For this reason, all kind of AI systems which are in place will be subject to product liability under the European scheme. The next question is, who is the producer? Who is the RSC of liability? And this is the producer of the AI system according to Article 3 of the PLD, as we call it. The producer is, addressee of liability is the producer of the finished product, but also the producer of any raw material or of a component. So if software is a product, in most cases a component, this programmer of such software will be producer and can be liable under the PLD. In the case of a neural network, which gathers its abilities or functions by training, as we know, the person who is conducting that training has to be considered as a producer for the simple reason that the neural network only acquires its functions or abilities via the training, and the training process which is initiated or steered or conducted by a person, that has to be the producer. To sum up, we don't have any difficulty in applying the PLD on AI systems, including systems which are based on machine learning, and we don't have any difficulty to make liable any person who is responsible for the functionality of such system or software. Now I would turn to the most difficult question in my view with regard to AI systems and product liability. As I said in the first part of my presentations, AI systems have the characteristic that they can show what I would like to call conduct or behavior. In this way, they're different from traditional products. A defect is defined as an insufficient property of a system. So we have to refer to the properties of the system and check if they are fulfilling the expectations or not. Insofar they are below the reasonable safety expectations, the product is to be considered as defective. So in the case, however, how can we apply that systems to an AI systems? Again, the self-driving car offers a simple example. If a self-driving car is running flawless for a million of kilometers or even miles? Is it defective if it causes an accident in the 1 millionth and first mile? This example makes it clear, in my view, that conduct or behavior of a system is not per se a property of the system. We should and have to distinguish between property and conduct. However, a kind of bridge between conduct and property can be established if we assume that the ability to behave in a certain way in a given situation can be considered as a property of the AI system. So the property, which is the reference point for defectiveness, is the ability of the system to behave in a certain way.
5 more minutes, Mr. Borges.
Excuse me?
5 more minutes.
That's exactly what I expected. Thank you so much. So product, just to make it short, is not a liability for faulty behavior. And this is important since we have to establish this ability. The next question, and in my view, most difficult question, is what is the reference point for the conduct? If you refer to the ability to conduct or behave in a certain way, what is the reference? Is it human behavior? So far, the legal framework doesn't offer any answer to this, since the legal rules were designed for humans, not for machines. Certainly, human capability can serve as a first orientation for safety expectations to AI systems. You should certainly expect that a self-driving car would behave similarly than a human driver, for example, would respect traffic signals or so. However, obviously, there's no limitation by the expectations are not limited by the reference of human capabilities. You definitely can expect a self-driving car to use the brakes much faster with a faster reaction than a human driver. It makes it clear that we need a kind of independent expectations for machine, which are designed to the capabilities of machines and not just apply the rules which have been designed for humans. And the next question is, what is the accuracy? In this conference, as in general, when we develop AI systems, we are proud of accuracy of our tools. But what is the accuracy which we have to expect from an AI system? Can we expect an error-free AI system? Can we expect that it will always, in any future situation, behave correctly? Is that the test? Is it 100% error-freeness what we have to demand? Certainly not, as this would be a liability for behavior, not for an ability. That makes it clear that we have to find out what the fault tolerance in case of an AI systems is, and it's obvious that this depends very much on the risks associated with such systems. You would probably expect a higher accuracy from an airplane or self-driving car than from an AI system which is supporting a lawyer in searching decisions or arguments. And the next question, the next challenge then is, how can we assess that the system fulfills the safety equations, the error, the required accuracy? And this goes via testing. That's why testing of AI systems play a major role in the concepts of liability for AI systems in the future. Proper testing can also be a safety expectation of the product itself under the PLD already. So even if you apply the common, the present legal system, testing can be part of it. The last point I want to mention is the most important one in practice very often, that's the burden of proof. Under the PLD, the injured person shall be required to prove the damage, the defect, and the causal relationship. So the burden of proof is on the victim. Under most legal systems in Europe, we don't have any tools to support the victim in collecting the facts. And even if we had some kind of pre-trial discovery, it is very difficult to establish the fact. For this reason, the expert group, which I mentioned earlier, is suggesting the shift of a burden of proof and say in certain situations. The expert group did not clarify under which circumstances such shift of a burden of proof should be in place. So the crucial question then is, what are the conditions for such reversal of the burden of proof? I would like to suggest a solution which I described in my paper, which is that the reversal of the burden of proof for defectiveness of a product should be in place in the case of faulty behavior of such product. So once we can establish that the AI system behaved in a given situation in a wrong way, the reversal of a burden of proof that the product as such is not defective shall be on the producer. To conclude, product liability can in general be applied to AI systems. One of the main challenges is to distinguish between conduct or behavior on the one side and a property of the system on the other side. However, we can bridge this by considering the ability to behave in a certain way as a property. There are two main challenges in my view. The one is the definition of the expectations regarding the accuracy of an AI system to behave properly. And the other one is the proof of a defect, the burden of proof of a defect. And here I would like to suggest to introduce a shift of the burden of proof for defectiveness in the case of faulty behavior. And that's it. Thank you very much for your attention.
Thank you, Mr. Borges. It was very interesting. Actually, there are many concepts of law that are being challenged by AI, and this is definitely one of them. We have a question from Mr. Adam Weiner. Actually, he is asking you to comment about the development of these issues in the UK and USA, if possible.
I'm not familiar with the recent developments in the US. In the case of UK, which was part of the European Union until very recently. So in the past, it has had the same rules. And of course, the PLD is still current legislation in the UK. So all I said for the current situation refers to the UK as well.
Okay. Another question from Marcelo Lopez is, if product liability law can be applied to situations involving discrimination or otherwise unfair assessments by AI systems, what could be done to encourage producers to avoid biases in their systems?
Thank you very much for that question, which refers to my next presentation. It's a very interesting one. To cut it short, in my view, testing is the answer also to fight against bias and discrimination, since the big advantage of AI systems compared to humans is that we can reproduce their choices. So they are open to testing. Even though there are limits to testing, just to give an example, it's hard to reproduce the Uber accidents, since there's so many factors and so many potential data which you can never really re-establish. Also, if you consider that an AI system would assess a person based on a video interview, the amount of data makes it very, very hard to do just exactly the same. So even though there are limits, testing is the very big advantage which we have when it comes to machine-made decisions compared to human-made decisions.
Okay, good. Francesco Sovrano is asking, what if it's not possible to assess a defect nor a lack of defect?
What if it's not possible to assess a defect?
Nor a lack of defect.
If you don't know if it's effective or not, in that case, there is no claim for damages. So the victim has to establish the existence of a fact, and if the facts do not allow the judge to assess that there was a defect, the case will be dismissed.
Okay, and can you have some comments about the Teubner ideas of you give a personality, legal personality for AI systems for liability issues?
Thank you very much for that far-reaching questions. As we know, the idea of a legal personality, which was brought up by the EU Parliament in 2016 and discussed worldwide after that, has not found many friends in most Western countries. In Europe, it was Estonia who showed a sympathy and announced some legal action, but later refrained from it. And most scholars in Europe strictly oppose the idea of legal personality of AI systems. Surprisingly, in other areas of the world, there's more openness to this. When I have a frequent exchange with Japanese colleagues, and interestingly, the colleagues in Japan were much more open to the idea of giving personality to AI systems than their European counterparts. So it is very interesting to see that even though intuitively a European lawyer would certainly reject the idea of attributing legal personality to machines, like I would do actually, we have to consider to see that the idea is not, it's not impossible to conceive legal personality. Certainly what we will need is an idea of addressing machines in their behavior. I hope I could make it clear in my presentation that conduct is not a property and that we have to deal with a system, a machine, which is behaving similar to, in its own way, but similar to a human who is also choosing his action in a given situation. And that point is just not addressed by the current legal system. And if that is an idea which you can take away from my presentation, I would be very happy.
Yeah, actually, it's a very, very interesting point of view. I really like it. Thank you very much, Mr. Borges. Now, I will introduce you. Sorry, do you have any more comments to finish? Any?
No, thank you. That was my closing remark already. Thank you very much.
Thank you very much.
The first one is from Anna Lauren, and she'd like to know, how could we deal with different levels of autonomy of AI systems? For example, there are many different levels of autonomy of autonomous vehicles. Should the legislator take this into account when creating rules on civil liability for damages?
Oh, that's a nice question, though a very tough one. It's difficult to, I have to go into much detail to properly answer to it, but let me cut it to a short answer. Yes and no. In case of rules like the product liability directive, which is very broad and has a general clause like notions such as product and defect, specific reference to level of autonomy is not necessary. Judge will specify. In other cases, however, such as specific liability rules for specific products or specific fields should take into consideration the risks, as the legislator should always considering a risk follow a risk-based approach, and usually a higher level of autonomy would involve higher risks. In my previous research, just to give an example, by way of example, I suggested the introduction of a specific producer's liability for autonomous cars level 4 and 5, however, not for level 1 to 3. So in some cases, it's important to distinguish between the different levels of autonomy. In other rule designs, it's not.
Thank you. I have a second question from Adam Weiner. He'd like to know if you can please comment on the impact of the legal changes you mentioned on software developers and companies.
Who am I to predict the future? That's really difficult, Adam. But I try to do my best. In the past, at least in Germany, and as to my knowledge, in many other European jurisdictions, we didn't have much cases on product liability for software, actually, since it was debated if product liability would apply to software at all. In the future, we might see some cases. I don't expect a huge wave of claims against software producers, even though in some cases, just remember the very tragic case of the Boeing 737, that the software with a defect caused tremendously damages. That might be the case. In most cases, however, software will be embedded and the producer of the finished product will be the one who is be the addressee of any claim. And usually the software developer or the software producer will be in a contractual relationship with the producer of the finished product. So in most cases, probably that will be dealt in that way. If more specific legislation will be introduced by the legislator, of course, that may change the game. But just the recognition that software and on the total is part of the software. A part of the product liability scheme. I don't see much changes in the meaning of very important liability risk for software developers.
Thank you, Mr. Borges. We don't have any more questions, but is there any point you'd like to address? Any further comments you'd like to make?
Not really, except for thanking the organizers of ICAL 21 for this very perfect organization. Thank you very much also for your interest in my presentation.